Welcome to SCOTUScast, First Amendment and Public Employees Edition. Thank you for tuning in. On April 26, 2016, the Supreme Court decided Heffernan v. City of Paterson. Jeffrey Heffernan was a police officer for the City of Paterson, New Jersey. A fellow police officer observed Heffernan picking up a campaign sign for the mayoral candidate running against the incumbent. Although Heffernan disclaimed any political motives and said he was merely picking the sign up for his mother, his supervisor demoted him. Heffernan sued Paterson, claiming a violation of his First Amendment rights, but lost on the grounds that, his supervisor's erroneous belief notwithstanding, the fact that Heffernan was not actually engaged in political activity doomed his claim. The U.S. Court of Appeals for the Third Circuit affirmed the trial court's judgment. The question before the Supreme Court was whether the First Amendment bars the government from demoting a public employee based on a supervisor's perception that the employee supports a political candidate. By a vote of 6-2, the Supreme Court reversed the decision of the Third Circuit and remanded the case. Justice Breyer delivered the opinion of the court, which held that when an employer demotes an employee out of a desire to prevent the employee from engaging in protected political activity, the employee is entitled to challenge that unlawful action under the First Amendment and Section 1983, even if the employer's actions are based on a factual mistake about the employee's behavior. Justice Breyer was joined by the Chief Justice and Justices Kennedy, Ginsburg, Sotomayor, and Kagan. Justice Thomas filed a dissenting opinion in which Justice Alito joined. To discuss the case, we have Adele Keim, who is counsel at the Becket Fund for Religious Liberty. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Ms. Keim.
The court's majority in Heffernan v. City of Paterson concluded that it was the government's motive that mattered, not whether the government employer was factually correct. This focus on the government's action tracks the text of the First Amendment, which Justice Ginsburg had dryly pointed out at oral argument, states that Congress shall pass no law abridging the freedom of speech. The majority's decision also prevents the constitutional harm of discouraging employees from engaging in protected political speech. This kind of protection is especially important during an election year, because we don't want a climate where government employers are looking over their employees' shoulders and making guesses about who they might be backing in the presidential election. On the other hand, writing in dissent, Justice Thomas, who was joined by Justice Alito, who happens to hail from the Garden State, argued that the mere fact the government had acted unconstitutionally does not mean that the plaintiff's constitutional rights had been violated. In other words, they focused on Officer Heffernan's motive and asked whether he had intended to exercise his First Amendment rights. They concluded that because he himself said he had not, there was no remedy for what was unquestionably a constitutional wrong committed by the government. The Becket Fund filed an amicus brief in this case, and we argued that much of the sound and fury relating to this case and others like it would dissipate if the court took this opportunity to reground its freedom of association jurisprudence in the forgotten freedom of assembly. First Amendment scholar John Inatsu pointed out that Justice Thomas's dissent is one of only a handful of recent opinions that recognize the right of assembly as distinct from the right of free speech. Freedom of assembly is in the text of the First Amendment and has been crucial in protecting the right of significant social movements, the abolition of slavery, the trade labor union movement, to share their ideas with new audiences despite sometimes violent opposition. Freedom of assembly protects the right to sit in on meetings, to meet people and ask questions, even if you decide not to commit to the political, social, or religious movement you're exploring. Viewed through the lens of assembly, the fact that Officer Heffernan was demoted and eventually fired because he was seen hanging around a campaign headquarters would be a real problem under the Constitution. The kind of thoughtful pre-commitment inquiry that freedom of assembly protects is crucial to a flourishing civil society, and not to mention a functioning democracy. So we at the Becket Fund agree with Professor Inatsu that the Supreme Court should restore the forgotten freedom of assembly to its rightful place as the guardian of all of the other rights in the First Amendment. If they'd done that here, perhaps the fractured opinion would have become unanimous.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.